My daughter has been a practicing attorney in Chicago for 15 years, as has her husband. Having those two in the family might be why I have a copy of Black's Law Dictionary not far from my keyboard. In the case of this memo, I consulted it and want to share with you a definition for conflict of interest, the topic of this month's column. To quote Black's, the definition is as follows: a real or seeming incompatibility between one's private interests and one's public or fiduciary duties. In the legal world, those few words say it all. For the rest of us, the following helps define the guardrails. A situation in which the concerns or aims of two different parties are incompatible. And B, a situation in which a person is in a position to derive personal benefit from actions or decisions made in their official capacity. What we as a society expect or demand is to have our legal affairs adjudicated impartially. We also expect and demand that same impartiality within the sports world. There has to be believability in outcome for fans to remain fans and for competitors and coaches to believe in their undertaking. That believability so very much includes the role we play in organized competitive sports. Now, we officials must have an innate sense of right and wrong, and of what likely is or could be construed as a conflict of interest. Your kid goes to a school. You don't referee that school. You graduated from an institution. You don't referee that institution. Your significant other is a fundraiser for a school. You don't referee in games that involve that school. You have been given a recognition by an institution. You don't referee that institution. You are involved in a business that services an athletic department. You don't referee for that department's school. Today, with the widespread use of online registrations for conferences and leagues, officials are asked a series of questions that have a bearing on a potential conflict of interest. To wit, list those institutions you or any family member ever attended, graduated from in any degree, or have a continuing relationship with. List those institutions you are an employee for or have been an employee for. List any relationship, business or social, that could cause a reasonable person to infer a team or school could benefit from your relationship with it. Yes, the standard is wide and the guardrails for us narrow. Such requires full and complete disclosure when filling out those forms. That is how it must be, because when we bust through those guardrails, our industry suffers greatly. I am so thankful that within officiating history, there have been so very few such incidents. When they occur, it takes decades for them to recede from the public's memory. That public likes to think we have favorites. Okay, but what about those times when such in-depth registrations don't take place? What about those times when many years have passed since you had a relationship with the school down the road? What about the situations when you get pressed into service because an official has to be found? Yes, there are gray areas to be considered, especially at the high school youth and club levels. Yet the key determinant has to be what your conscience says to you. If you have angst about whether you should accept an assignment, slow down. Ask yourself this: would public awareness about my situation, my context, feed a perception that I can't be fully impartial in that game? If the reasonable answer is yes, the decision is easy. Walk away from it. Err on the side of impartiality. When in doubt, rule it out. Thank you.